So, hello and welcome. I'm Jeanette Eicks, and I am a law professor at Vermont Law and Graduate School, where I take part in the Vermont Small Business Law Center. And today we're going to talk to you about hiring your first employee. This is a wonderful opportunity for us because we allow our second and third year law students to present this educational legal information to you. And in doing so, they gain information and education and perfect their presentation skills. So without further ado, I'm going to let Laura Herman and Octavius, what's your last name? Help me here. Henderson, um, introduce themselves.
Hello, everyone. My name is Octavius, and student here at graduate school. I'm also a clinician.
We're having trouble with your sound, Octavius. So I'm gonna let you try that again.
Can you
Um,
hear me?
yes.
Okay. Hello, everyone. My name is Octavius Henderson. I'm a third year law student here at Vermont Law and Graduate School, and I'm also a clinician here at the Small Business Clinic.
All right, Laura.
Hi, everyone. I'm Lara. I am a second year law student and have experience running my own business for 5 years. And so I love working with small business owners in the clinic.
Super. And so without further ado, I'm going to hand this back to CVOEO and Sophia to give us the introduction.
Yeah, thank you. So we are really grateful to have all of you join us. This webinar is in partnership with the CVOEO Microbusiness Development Program and Vermont Law and Graduate School. I will be the tech support today, so please keep yourself muted when you're not speaking. Make sure that your name shows up, which it does for all of you, so thank you for already getting that all set up. If you have any questions, throw them in the chat. Simeon and I will monitor that and make sure that they are attended to. And after this workshop, know that you will receive a copy of this presentation along with other links to resources and contact information that we go over during this intro. So without further ado, I will pass it off to my colleague, Simeon Geigel.
Good morning, everyone. Thanks so much for joining us today, and thank you to the folks at the Vermont Law School for presenting today. We really do appreciate your time and expertise in sharing this information. Just a very quick introduction for the Microbusiness Development Program. The Microbusiness Development Program is a statewide program that helps low to moderate income Vermonters start or expand a business. There are no fees or costs for our services that folks incur when they connect with us. And folks do need to qualify, however, and qualification is based on the number of people in the household versus the household's total income for the last 30 days. If you're interested in connecting with our program for free business counseling, please don't hesitate to reach out to us. You can see my contact information there, as well as my coworker John Gergley's information, who's on our class today as well. And this information will also be included in the information that Sophia will send out afterwards. Just a couple of quick shout outs and thank yous to our partners, which include the People's Trust Company. They offer a variety of commercial and business banking products and services, as well as business consulting services to help their clients succeed. And you can see Jay Cummings' contact information there. So if you have any questions or interest in accessing their services, please reach out to Jay. And finally, thank you to our partners with the that are part of the industrial development corporations, and specifically the Lake Champlain Islands, the Greater Burlington Industrial Corporation, the Addison County Corporation, and of course Franklin County. And they are excellent resources as well for your business. So they are very, very helpful. So we encourage you to reach out to them as well as you are looking to build your business. Finally, I mentioned that the Microbusiness Development Program is a statewide program. At the bottom of this slide, you'll see a website for mbdp.org, and there you can access more information about our program and the specific contacts above that you see. The contacts above are for the different micro businesses that cover the state. In the southern region, covering Bennington, Rutland, we have Brock. Capstone Community Action covers Washington, Lamoille, East, and Orange counties. CVOEO, our program that John and I represent, covers Chittenden, Franklin, Grand Isle, and Addison counties, and finally, NECA up in the Northeast Kingdom, covering Caledonia, Essex, and Orleans, and finally SEVCA covering Windham and Windsor counties to the south. We do need to update both Brock and SEVCA's information on here. Perhaps that's something we can include in the email that we send out to folks. Last but not least, of course, we like to make sure others are aware of the other business development support services in our area, including the Burlington Business and Workforce Development Program, the Center for Women in Enterprise, Mercy Connections Women's Small Business Program, the Vermont SBDC or Small Business Development Center, the SBA, Small Business Administration, and finally Champlain Valley SCORE. So these are all wonderful programs that are there to help you as well develop and build your business. They also offer classes and one-on-one help. So Jeannie, I will turn it back to you, but I would definitely like to once again just thank you so much for taking the time today to present on this topic and share your knowledge and expertise with us. We really do appreciate it.
So without further ado, we did our introductions. I'd like to share with you our plans for today. Our students will be rotating back and forth between their slides. So, and if you have any questions, feel free to put them in chat. Simeon is amazing at how he sort of helps us direct this to really answer your questions. So we're looking forward to that continued support. All right. So my students can go ahead and kick this off.
Okay, what are the risky spots for a small business organization hiring employees? What to know before you hire. And it starts off with the transition process, which is the hiring, firing, and promotion process. So this is when a business owner wants to know if they're hiring an employee or an independent contractor or both. And to know this, you have to ensure that your hiring process is deliberate and concise. You don't want to rush and you don't want to misplace employee or independent contracting. And during the hiring process, you want to displace any biases or discriminatory practices to ensure that that you're complying with employment laws, both in state and federal.
And I would add to this is the plan before you hire. So when you're thinking about these are the spots where you have to pay a lot of attention as you're thinking about employees. And we're going to talk about these as we move through the slides.
Yes. And for management, you want to know whether or not your business needs an employee handbook or not. Is it required? Is it not? Most businesses are not required, but we'll talk more about that later on. Will your employees be given a performance review? Things like that are important. And you want to make sure that you document everything that will affect the business, whether that's a conversation, an interaction, or transaction with an employee, with the person that's coming into the business, or somebody that you're doing business with. Everything should be documented.
And I would add to that, you're going to hear us preach documentation throughout this conversation today. If you take nothing else away from this, take away the fact that you have to document any interaction between your employee and the business. Always document everything. It's a good practice for all things legal and all things in your business, but particularly with regards to human resources, HR, employment situations.
And several.
We're going to head into recruitment here, I think.
Okay. Okay, great. So these are the several potential risk points for discrimination claims and recruitment. You want to ensure that not advertising, the application process, the interview process, and any hiring decisions do not contain any any room for discrimination. For advertising, you want to make sure that you're advertising the job offer for the requirements and skills that are needed for the job. You're not necessarily saying we will only hire a specific area of people, because that's not something that you can do. You can say we want to hire someone that can lift 50 pounds. You can't say that we will only hire someone that's husky and Hulk Hogan like. You can't say those sorts of things because that's not
And there
allowed.
are things you can that sometimes you think are positive, right? Like we're looking for young college grads, right? But when you say something like that, what you may be thinking about is creating opportunities for those graduates. What you've done then is displace perhaps those that are aged. So you have to be very careful with even what you consider positive.
Right, right. And on the application, you can't question someone's criminal history or their salary-based history. There are ways around it during an interview process, but just at basis, you can't ask these things on the application.
In the interview?
Yes, in the interview, there's ways that you can shape your questioning because it's usually not what you say, but how you say it. So in the interview, you could say, um, is there anything in your background that you would like to share with us before we perform the background check? Or for the salary, is there an acceptable salary that you're looking for this position? So instead of just asking things in kind of like a weird way, this is more of like making it a collaborative thing with you and the potential employee, sorry.
You're
But
right.
certain things that you cannot ask about is about marital status, religion, age, family status, medical history, and when the person graduated. And you cannot pull credit history without prior authorization from the state.
So can you do a criminal background check on an employee?
To my knowledge, yes, you can.
You can. Absolutely. Simeon, you have a question?
Yeah, would you mind just popping back to the last slide for me? So I'm just wondering with the question that relates to salary, can you give an example of how you shouldn't ask that about their salary or criminal
What
record?
did you earn in your last job?
Hmm,
Yeah, that's right off the table. Don't ask that.
okay.
Um, and are you a convicted felon? Yeah, you can't ask that. What can you ask? As Octavius was saying, when you're in fact, some positions you want a background check. So let's think about childcare, right? You may want to do a criminal background check on your employees for childcare for peace of mind and even requirements in some towns and locations. They require background checks. So you have to get their authorization, you have to ask for it, and the applicant signs off on allowing you to do that background check. And then, as Octavius was indicating, that's when you say, is there anything you'd like us to know before we run the background check? And that's when you start to know maybe this isn't the right person for the position. Hey, it's a convicted felon and we don't want them working with these children or whatever it is, right? It's a convicted pedophile, for example, and we don't want them working with the children. In fact, it's forbidden. So that's the sort of thing that you want to be able to catch by asking very carefully worded questions that are more broad and inviting them to tell you about things. Um, and we said there's some off-limit questions here. You really don't want people telling you their age. They may tell you, they may volunteer some of this information. When they do volunteer it in an interview, what they've done is they've created a situation in which you could potentially discriminate against them for that thing. We don't You don't want that information from them. If there's a way to avoid getting that information from them, you're in a better position because as soon as they give you that information, you've been put in a situation that can be awkward. For example, someone comes in and says, I just want you to know that I'm pregnant. You don't hire them. And you hire someone that is a male who is the same age, same qualifications. You can start getting into a situation where this person, it appears that this person was not hired because they were pregnant. Maybe they just weren't the right fit for your company. That's fine. And you're absolutely within your rights to not hire them. However, because they told you they were pregnant, it can create a question. And that question can then be pursued in a lawsuit. So you want to steer as far away from those kinds of things as you possibly can.
Yeah, but if an applicant throws that information out without having it been solicited, that's potentially I mean, maybe they're using that information to their benefit because
Absolutely.
for exactly the reason you just stated.
It can be a rough series of things that you have to navigate when you're hiring. And hiring is risky. Managing employees is a risk for your business. There's a reason why these farm families have so many children and they all work on the farm, right? I mean, there's no hiring involved in that. They're families, so a whole different set of rules apply, right? So these are the things that you have to think about and tread lightly and with caution, right? Simeon, you have your hand up.
Yeah, could it be handled as simply as before the interview starts? Can you say, please don't share information about your legal status, religion, age, and just go down this list during the
Yes,
interview? Okay,
absolutely.
that's a very practical, easy answer for this issue then
It
potentially.
is. But
Okay,
people who are personable, it's hard for them not to talk about their family.
right.
It's hard for
Right.
them not to mention their kids, right? So if you're going to have the kind of interview you want to have to see about fit, it's you know, and if you're, let's use the childcare example again. You're hiring for childcare. The people are going to talk about their kids. It's
Mhm,
sort of this thing that happens, right? So how do you segment and separate? It's cautionary tale, right?
mhm,
And tread carefully and make sure there's no judgment made in response to any of that information they give you.
mhm,
For example, if someone says, I'm 3 months pregnant, the thing you don't want to say is, oh, you'd be leaving the job in 6 months,
mhm.
right? I mean, it sounds obvious, but don't say that. That's bad, right? So these are the pieces you want to avoid.
Okay, thank you.
All right.
But
Octavius.
wouldn't it be a wise, I mean, I would simply ignore the comment. I wouldn't even recognize it.
That is the best way to go. Don't engage it. Okay, Octavius.
Other potential risks is to ensure that the job offer matches the duties that the person being hired is asked to perform. Um, Maybe an example is you hire a cashier. They probably shouldn't, be outside flipping a sign in a hot dog suit because it doesn't match their job description. Um, and the onboarding process should be collaborative because this person is coming on to work with you and they're providing you with sensitive information before they even start working for you. So the more collaborative it is, the easier the process is to go. And some of those forms are an I-9, which is an employment eligibility form, should be completed 72 hours before the person starts to work at the business. And direct deposit, because most businesses don't write checks anymore. So this person will be providing you with their bank account information and sometimes their social security information. So that's something to be considered for. And emergency contact. In case something happens at work, you want to have somebody that you can call to come and pick them up or to notify them that person A has been in an accident or something happened. And the W-4 is the tax information and then the employee handbook. And usually that's not all businesses are required to have that. Businesses that it's just a business and one employee, not really required. But if it is a childcare situation, if it is a childcare business, they are required to have an employee handbook. And it's not required by law, but it is heavily encouraged because it's a way to give the employees notice of their rights and responsibilities while they're on the job. It can sometimes limit liability in some ways because the employee is on notice of their rights while they're on the job.
What's the flip side of that? What are the challenges that come with having an employee handbook?
You don't want to put anything in the employee handbook that the business is not going to hold up to, because the employee handbook is a contract between the business and the employees, and it's something that can be held up in the court of law. So if the business does not intend to stand by whatever's in the handbook, they might not want to put it in there.
Demand.
Yeah, just to clarify, when you say make it collaborative, is that relating to the list that you just went through, or is making it collaborative something else and different?
It's relating to the list. So one of the things when we said document,
Mhm.
all of these things we've gone through here require signatures. The employee is turning that information over to you and they're doing it voluntarily, right? And one of the things we require when they turn those things over is a signature saying this information is accurate. We haven't given you anything, particularly for things like I-9s. I-9s, for those of you that aren't in the loop, are the way we ensure that you can work in the United States. So this is about your citizenship, right? And so, or do you have appropriate green cards or visas to work in the US, right? So that's that kind of thing. A really touchy subject right now. There's some great Department of Labor information on that in the state of Vermont for anybody who has questions about that. Um, direct deposit. Again, if you're moving things into someone's or out of someone's bank account, right? You need their permission to do that. And when I say moving out, yes, sometimes businesses do that, right? So let's say you directly deposit too much salary or there's an error, right? Somebody had hit an extra zero when they put it in, right? And suddenly you have a $10,000 paycheck instead of $1,000 paycheck. Those errors can happen and you want the ability to take that back. And that's part of what that direct deposit authorization will give you. Emergency contact information, you want them to sign off that these are the people they want and that you can share their information with them. Because in an emergency situation, that could be healthcare information and you want to be able to share it, right? W-4s, that's a tax document. Employee handbook. This is going back to what Octavius was talking about just a second ago. If you put it in there, you've got to follow through with it, right? And that signature is the employee saying, I've looked at this, I've read it, you've presented me with it, I understand, I'm bound by it. So not only are you required, employer, to do what you said you're going to do, but I'm required to do what you've asked me to do. Simeon?
Yeah. So, I just to, I guess I'm a little confused with the employee handbook. So I'm curious. Maybe you'll get to this in your presentation. So, why wouldn't? Well, I know you explained this, but under what conditions should somebody have that, and why wouldn't somebody want to have an employee handbook? And how does somebody make that decision to have one, especially if they're just hiring their first employee?
So I would tell you that the jury is a bit out on this. Lawyers will disagree on whether or not you should have an employee handbook. And here's why. A small business is prone to do things on the fly a little bit, right?
Mhm.
And adjust at the moment, in the moment. When you have 2 or 3 employees and you're all working together to keep this business running and it feels more like family, less like business, that's when those employee handbooks can really preclude that kind of flexibility that you might need in a momentary situation, right? Because they're rigid. On the other hand, when you have 10 or more employees and you really need to start having processes and procedures and reviews and things need to be done in a timely basis, it really becomes more process and procedurally oriented. And that's when you have to have that employee handbook, is when you've got those processes and procedures. If you tell somebody coming in that they're going to get an employee review every year, then you need to set up a time to do it and have that done, right? And some businesses choose to do employee reviews every April. Some businesses do it on your work anniversary. Whatever it is you do, you write it in that employee handbook. Some employers do it every 2 years, some do it every 6 months. Whatever the appropriate thing is, you want to put that in and then you have to live up to it. And that's the other piece of this, the have to,
Mhm,
right? Some small businesses just don't have the resources to meet those. They set these grand goals for themselves and then they can't meet
mhm,
the goals they lay out. So be self-aware as a
mhm,
business. Know that, hey, we're holding this together and we're just barely hanging on. Some of the employee things that would be nice to do, you can't do. Right. And so you may set yourself up for these great expectations that you can't follow through on, and then you've put yourself in a liability risk situation.
Okay. Using your example of an annual review, can you have an annual review even if you don't have an employee handbook?
Absolutely.
Okay.
Absolutely. Just because you don't have an employee handbook doesn't mean you can't do all of those things. It doesn't mean you can't have procedures. It
Mhm,
just means you have not informed your employee in writing and promised them those procedures in a
mm,
specific time, right?
okay. Okay.
There's a difference between making a promise, because as Octavia said, an employee handbook is a contract between the employer and the employee, right? And suddenly that becomes much more rigid and much less flexible,
Okay.
right? Some employee handbooks you'll see, the employee review will happen within 90 days of April 1st each
Mhm,
year, or something as crazy as that.
okay.
This is why lawyers disagree on
Mm,
employee handbooks, is because there are pros and cons, right?
sure. Yeah. So just a few more follow-up comments and questions on this. So, if people are working through the Vermont Law School and have a lawyer assigned to them, is it possible they could get that lawyer to advise them on if they should have an employee handbook
Absolutely.
and do that, provide that service?
Absolutely. And oftentimes the way the employee handbook works is the employee puts together all of the things that they want in it
Mhm,
and takes that to an attorney or to an HR professional, frankly. Sometimes HR professionals, there are good consultants in the HR world who can help you put that together. And then once that's done, take it to the attorney to review to make sure you haven't promised anything you shouldn't. And that you're not creating liability for yourself, right? The attorney can, I wouldn't use an attorney to write the thing. I would use an attorney to review the thing,
okay.
because it's a better expenditure of legal dollars. Um, you know, that it using an HR consultant to do the initial policy work and then making sure that that is a legally both relevant and document you want to be bound by, that's those are the pieces you really want to make sure of.
Okay. And maybe you'll get to this later, but when it relates to the I-9, the W-4, and other basic relevant labor law things that folks would need to know, will you have those? Are you identifying those resources later in your slideshow, like the Vermont Department of Labor, the IRS, et cetera?
I'm not sure if we have those in resources or not, but we can make those available to you and
Oh,
send
okay.
send the links.
Okay.
The Vermont Department of Labor website is excellent and has a full list of these things. We're going to talk about signage in the workplace and other things later. Again, it's a checklist that the Vermont Department of Labor has. The folks at the Department of Labor are great to talk to too. If you've got a question about this stuff, call them, ask. The I-9 stuff is particularly tricky right now because one of the things we're seeing is this is the one thing that ICE can come in without a subpoena and demand of a business is to see their I-9s. So you have to keep those as a record and be able to hand them over on any employee you have at any moment. So really, and there are some significant fines involved if you do not have those. So be very careful of that. We're at a time where that has become a critical need for businesses to have and meet that.
And I guess the last thing I'll mention, and if you're able to just speak to this in any way, great, but just to mention that this information you're collecting on your employees should be considered confidential and protected. So with that in mind, I think it makes sense.
At minimum, a
Yeah.
locked filing cabinet.
Yep.
Other folks, this is safe material as well for some small businesses. You know, I see small businesses put these things in fire safes. It's what we call in Vermont personally identifiable information, or PII. PII has to be protected. If for some reason you believe it was leaked, lost, or otherwise breached, you must notify the Attorney General in the state of Vermont within 72 hours. This is significant stuff. You have an obligation and responsibility to hold it closely and to not let it be given away to anyone that is not authorized to have that information. This is tricky right now, as we're seeing in the public headlines. You know, there are those that perhaps are not authorized that are going in and getting information that they may not have authorization to have. As a small business, you're going to have to make some of those calls about who's authorized to see what information. I don't anticipate it will happen for small businesses, but stranger things have been known to happen. So we're in a situation where asserting those privacy rights on behalf of your employees could become litigious.
Mhm. And if you keep this information on your computer, that would require you to stay on top of security and perhaps have cyber security insurance in case you're hacked.
Always carry cyber insurance. There is no world in which a business does not want cyber insurance these days. And you encrypt these documents. That
Mhm.
is the only way to ensure that you've met the minimum standard of care, is to make sure that all documents are encrypted. There are third-party HR solutions and record keeping that will do this for you. That's kind of nice because when you sign up with them, they indemnify you. And that means that they take on any liability you might incur for loss of this information.
Thank you.
Right. Octavius, are you next on this, or is this Laura?
It's me.
Okay. We did finish everything out. Okay, Laura, you're next.
Okay. Managing employees. So every employee, as every person, is different. We all have different personalities. We all learn differently. We need to be managed differently and communicated differently. And it's like really important as a small business owner to understand that each person is unique. At the same time, your performance reviews need to be consistent, and it helps create consistency while managing. For example, if you run a pizza business and you're doing a performance review for two pizza makers, and one of the reviews talks about toppings and like how good they made pizzas, and the other one didn't even mention that, that's inconsistent, and it will not allow your employees to understand your expectations and how they can improve and move forward. Again, with the employee handbook, if you say we're doing reviews every 30, 60, 90 days when you are hired, after you're hired, you have to stick to that per your handbook, because again, it's a contract. If you don't have a handbook, just make sure those performance reviews are consistent. This positive workplace is critical. We've all probably worked in toxic environments, and as a small business owner, it's up to you how your workplace is going to be. You can maintain positivity with providing feedback quickly. If you see your pizza maker is doing 5 pepperonis instead of 10 pepperonis, instead of getting angry in your head about it, maybe just mentioning, hey, this is how we do it. Probably doesn't need to be documented, but that's up to you. And then help that employee learn how to grow. But also document too if it's egregious. As we say, document. And then if if the employees are doing great, it's always important, beneficial, I guess, to help them grow within your company, providing the feedback and allowing them to maybe move up in salary or job title, etc. And then if they're not doing so great, maybe you can work on an improvement plan. You should work on an improvement plan with them and document what you talked about and how you see that they need to improve, and have them sign off that they agree on taking those steps to improve. Yeah, and so that's everything for that slide, I think.
So Laura, does an employee have to sign off that they agree to do the things in an improvement plan?
They don't have to sign off that they agree. It would benefit the company if they signed off that they acknowledge that they saw what you have documented.
So I think the distinction here is they don't have to agree to do it. They don't have to agree with a performance review that you give them or an improvement plan, but they do have to sign off on seeing it and that you agreeing that you did in fact present this to them and they did see it. There's a distinction here. And it's really critical for businesses to know that they can press an employee to acknowledge that they have seen it, and that can be a fireable offense if they do not choose to acknowledge. Simeon.
Yeah, so two questions. One, is there any difference between what you're explaining here in terms of managing employees versus you have family working for you, whether it be children, relatives, etc.? And kind of a second question to that is, if you're hiring people seasonally, to what degree do these things relate?
Family seasonal?
Oh, no,
I
sorry.
need more
Yeah,
clarification.
no. So for example, if you're hiring family, say, to work in your restaurant, okay,
Mhm.
what applies to on what you're discussing here to family? But a separate question is, if you have a seasonal business and you're hiring people seasonally in the year, what applies here to seasonal hires, even if they're not family, they're just in it could be a totally separate business. So I'm just trying to separate the question for you.
Okay. Laura, can you?
So yeah, I'll try to take a stab at it, and then so family, there are certain rules when it comes to children, for example, but if they're adults, they would need to be an employee or an owner of the business. So they would, if you're putting these performance reviews together for your employees, that includes your family. You shouldn't be inconsistent with,
Same rules apply to
yeah.
family, with the exception of agriculture.
Okay.
Agriculture has some odd family related rules, and I don't have the specifics on that. If you want follow up on that, it's a more in-depth question.
No, that's
But
okay.
ag is excluded in many circumstances around family because of the family farm. But by and large, if you have a mom and pop restaurant and you hired Uncle Joe to be your short order chef, Uncle Joe gets the same protections as anyone else. If they're your children and they're minors, they don't. However,
And
they can't work unless they're over a certain age either. So there's a whole series of things you've got to worry about when you have your kids helping you out in your employment circumstance. Again, it has a little more specificity depending on the working circumstance, and we're not going to get into those details here.
Sure. Do you know if off the top of your head, if the Department of Labor clearly talks about those differences when
It
hiring?
does for ag. And it's real clear on ag.
Okay.
And it's clear on child labor.
Okay.
What is not as clear is when those children are yours.
Mm.
And that can be a little bit of an iffy situation. What's the difference between doing a chore for the family and, right, being an employee, right? And so that line can get a little iffy. Obviously, if you have them serving tables in a restaurant at 15, it's a little different than if you ask them to stop on the way home and pick up the business mail,
Mhm.
right? So gets into some dicey areas, and it's going to be specific to each situation, and you want to talk to your lawyer about that. You really do.
Okay. Thank you.
You're welcome. Laura, go ahead.
And for the seasonal, I would say it's everything that I said about like managing employee, I think would relate as well, just in a different way and different for ag. So yeah.
And one of the things we will talk about seasonal employees a little differently further on, because unemployment insurance hits that a little differently, and how you're managing seasonal employees, because it's a cycle, right? And it's not continuous employment. And so that is slightly different. And like annual employee reviews is kind of weird when you're only working for 3 months out of the year. On the other hand, say you're the rescue squad at the ski resort, it's important to get feedback about the job you're doing. So oftentimes those seasonal employers will have a scheduled review at the end of work, particularly for employees that come back year after year, right? And then your employment next season requires a positive review from this season or something of that nature. And they set that up, and it's pretty tight for jobs that are safety dependent or in other ways really impacting the public. It's less specific when it's the waiter at the ski lodge, right? All right,
Thank you.
go ahead, Laura.
Okay, I'm ready for the next slide, I think.
Okay.
Okay, so when you do have to terminate an employee's employment, you do need to handle it carefully in the terms of you don't want it to backfire and create litigation. So always documenting, having a witness is really great. If you can't have a witness, maybe have it be over like a camera that's they're aware of. That's like I think of restaurants and how there's cameras everywhere. So, but a witness is great. Sticking with the facts, and that comes with the employment reviews too. You can show we talked about these things and we didn't see improvement, and that's why we need to let you go. Trying to stay unemotional about it, and don't say I'm sorry, and then like terminate all their access to all of your documents and everything immediately is important.
Do you have to give a reason?
You don't have to give a reason. And it's at will employment, but it's important to say that you can fire somebody for any reason or no reason at all. You have to include no reason at all. Otherwise, you're going to have to include a reason.
Right.
And then the next section here, we talked about a little bit, but the Constitution protects these certain classes, race, gender, disability, age, all this. So you can't discriminate people based off of those protected classes. And, but we talked about that a little. And then for disability accommodations, the ADA, it triggers when you have 15 or more employees. And then you have to provide reasonable accommodations for them to work at your business. And then, I think we talked about the age and everything. Do you have more to add about that?
So let me let me ask you a question really
Okay.
quickly, and then we'll get to Simeon. Um, a reasonable accommodation for disabilities. Let's say you have someone that wants to work for you in a wheelchair, and you're running a museum based in a historically accurate building that has no ramps. Is it a reasonable accommodation to install ramps for this employee, or is that something that's not reasonable?
I think I would have to look up the definition of reasonable.
And I think it's fair to say it depends, right?
Okay, yeah.
There's no one answer for this. If your building has been, you know, put into historical registry, it could be you can't change it and you're forbidden from changing it. Then that becomes a situation where the accommodation is not reasonable. Sometimes it is not reasonable to ask an employer to accommodate someone when the cost is too great, right? Installing an elevator, for example, in some businesses is just prohibitive and you can't do that. And it's okay to not be able to accommodate people in those circumstances. However, if all they're looking for is a lower doorknob or something of that nature for it to be accessible, or bars in a bathroom to help them move to the commode, right? That is an accommodation that's reasonable, and you have to make those sorts of accommodations. So there could be costs involved to hiring those employees, and you cannot discriminate during the hiring process based on the accommodations that you foresee. All right. Simeon.
Yeah, I'm just wondering if you, unless you plan to talk about it more down the line, but if you could elaborate a little bit more on what it means to be an at-will state, and also if you can explain why you shouldn't say "I'm sorry" when you're probably trying to have a very human moment and it seems counterintuitive.
And really hard.
Yeah.
Having run my own business and let people go, it's really hard when they're in your office crying, not to say I'm sorry. It's our instinct, particularly those of us that were raised in the Midwest. We apologize for everything anyway. So I would say that's like the hardest thing ever. And I'm gonna let Laura speak to this. Maybe she has some better ideas.
Um, I think that there are ways to show kindness and empathy and without saying I'm sorry, because I'm not like I think that I'm not sure why to specifically not say I'm sorry, except for that it kind of makes you it because you're sticking to facts, and so you're just trying to be factual and not emotional. But I think you can still be empathetic without saying I'm sorry, and
Saying I'm sorry accepts responsibility,
yeah.
as though you did something wrong in the circumstance. And that's why you can't say I'm sorry. Um, on the other hand, you can say, I know this is difficult. You have my sympathy. This situation is hard, right? And there are ways to be humane. I had to work on this. So, you know, um, there are ways to be humane without saying I'm sorry and without taking responsibility. You can say, I know this is difficult. Here are the things we have in place. For example, this is a great time to tell them about things like COBRA insurance and things of that nature that can help them transition to another position, right? And in some cases, when you are ending employment, it might be a layoff, right? So there's nothing we can do about the circumstances is perfectly reasonable to say, right? So, or as you know, this is seasonal employment, right? I mean, there are ways to handle these things that are specific to each circumstance that help get you off the hook for I'm sorry. And your other question, Simeon, was which
Oh,
part?
oh,
At will.
yeah, at will. Yeah.
What does it mean to be an at will state, Laura?
So at will state means that you can fire anyone for any reason, and it doesn't, or no reason at all. You can just let them go without explaining why.
And in some cases, when there has been a great deal of friction in the work environment, it's better to do it that way. And frankly, the cost of the unemployment insurance bump that you're going to get is way better than the litigation over any words you may or may not have said at the point of separation.
And just to confirm, Vermont is an at-will state.
Vermont is an at-will state.
If you happen to live by a border of one of the other neighboring states that's not at will, I'm assuming that it would still follow Vermont at will if they live in another state, but they work for you.
As long as they're not working for you in that state, yes.
Okay. Okay.
Right. So if you hire them and they do deliveries for you in that state, you start to get into that who's got jurisdiction question. And it's not always as clear and apparent in those circumstances, particularly if you're registered as a foreign business in that state. So that's a go see your attorney question at that point, right? Because there's distinctions involved in it and it depends.
Gotcha. Thank you.
All right, Laura.
Okay, I'm ready for the next slide, I think.
Yep.
Okay, so yeah, it's important to know the different employee statuses, which we talked a little about some of them. The biggest, so you can see those, the biggest questions that come up, I would say, are the difference between an employee versus a contractor. And so I'll talk about that a little bit. In Vermont, the test for a contractor is a little bit more strict than for the federal government, how the federal government sees your employees. Vermont sees it a little bit stricter. So follow the Vermont. I would think it'd be better to follow the Vermont test. And their test is the ABC test. Does the person have what degree of control and direction does this person have? Is it outside the usual course of business? And does that person customarily engage in that trade? For example, if you have a wood-fired pizza business and you need a new pizza oven, so you hire somebody to build that pizza oven, the degree of control and direction would be, I need this pizza oven built probably by this time, this type of oven, and they have control over how they meet your deadlines and your wants, I guess, versus if you told an employee to do that, you would have complete control over how the employee builds the oven. And then obviously building a pizza oven is not making pizzas, so it's outside of your usual course of business as a pizza restaurant owner. And then that person probably is also a mason who builds pizza ovens. So that person would meet the independent contractor test and you could pay them that way. It's important to figure out that distinction because if you're treating someone like a independent contractor, but Vermont sees them as fitting an employee role, you might have to pay the taxes that were owed if they were your employee. If they're an independent contractor, they pay their own taxes. So that's like the most important.
And it's expensive because, as we all know, when you make an error, you also have to pay fines and fees and interest that goes with that. So if you have been treating someone like an independent contractor for 2 years, you owe 7 point something percent of their whatever you've paid them to the government, and all the fines because you didn't pay it on time, and the fees that each missed deadline incur. It gets expensive fast. We're talking tens of thousands of dollars in a heartbeat, right? The other piece I
And
would
yet the violations of this are incredible. We encounter it all the time.
Oh, absolutely. People think, and here's my big cautionary measure. People think that if they have a contract with someone, that they are an independent contractor. That is not the case. You cannot write words that say you are an independent contractor and poof, they're an independent contractor.
Right.
That's just not how it works. It works independently of any words you have in an agreement. One way to ensure that you're off the hook in this is if you're contracting with a business, right? If you're contracting with another business, and this goes to customarily engage in independent trade as part of the ABC test. Often people will work out a deal where the individual sets themselves up as a business and gets their own EIN, et cetera. And as soon as they start taking on the trappings of an independent business, you're off the hook. They're an independent contractor, even if they're a sole proprietor or whatever. On the other hand, this is really dangerous. If there's any chance they're an employee, assume they are in Vermont. It's really safer. Um, I've seen way too many people get stuck with the fees on this.
Have
And
you
they
really, so you've encountered people being caught? Because I've never heard of anyone being caught for this or fined or anything.
audited. It gets caught in IRS audits. And when it's caught in an IRS audit, it'll eat you alive. And I'll use an example from my early days after I graduated law school. I worked as an intern, almost a paid intern, um, for a law firm. That law firm said I was an independent contractor, and 3 years later, in an audit, they were caught and had to pay back over
Wow.
$100,000 in fees because they had treated all of their interns that way as
Mm,
independent contractors. And this was a law firm. They should have known better.
yeah.
So, so what I would say to you is when they get caught, it's really expensive.
Yeah.
And you can get caught in an audit. And if you play anything close with the IRS and you get flagged for an audit, this is where you're going to get caught. And then it's not just the feds that get you, right? They then turn it over to the state of Vermont and they get you too. So you get double whammy. Not fun. So don't do it. Always, always lean into employee relationship. It's just cheaper.
Before you go on to the next slide, do you mind if we just take a quick pause and I can ask people if they have any questions to this point?
Please.
Okay. Anybody have any questions to this point? Is something unclear? Is there a follow-up comment or question to anything that has been discussed? I'll take your silence as a no, but please feel free to unmute and ask your question.
And Laura, I think, has exempt versus non-exempt because there's a whole assortment of crazy that goes to this as well if you misclassify. So go ahead, Laura.
Okay.
I have a question before we
Sure.
go on. When you're talking about documenting everything,
Mhm.
I have an app that I use for customer client interactions and staff interactions. Would that be considered documenting my
Yeah.
interactions if we communicate through the app?
As long as you have a record of it afterwards, right? So does it preserve that communication?
Yes.
Most apps these days and most software preserves communication because it's required for legal purposes for discovery. And so they journal it in some way, but make sure that not only is it one documented, but two, it's accessible to you after that. Those are the two criteria. Some businesses now, or some software platforms now document it so they can feed it to their AI machine and don't tell you. That's a whole different thing. And that's not accessible to you, right? So make sure it's accessible.
Thank you.
You're welcome. Go ahead, Laura.
Okay, so exempt versus non-exempt. Mostly every employee is non-exempt.
It's always feels reverse there. I
Yeah.
know.
Unless they're salaried, and they have they have hiring and firing authorities, kind of like think of the
Pause
manager.
a second. What's the difference between exempt and non-exempt?
It's has to do with, well,
It's hourly versus salaried pay.
yeah, and non-exempt can have overtime or pay over like 40 hours. And if you're salaried, you can't, even if you work 60 hours.
Right.
Um, Yeah, I think I think I'm
So
off track now. Okay. Do you want
hourly versus salaried pay, right?
Yeah.
And the key to this is everybody wants to put employees on salary, right? Because then you can get as many hours out of them as you want and pay them one fee. Yeah, that's not how it works. It has to meet certain criteria. Um, and that judgment is hard, right? And figuring out what qualifies for salaried, it's generally professional positions. There's a whole list of them at the Department of Labor, what qualifies as salaried and what qualifies as hourly. Hourly employees are employees that are doing specific task-oriented work for you. Salaried folks have independent discretion and generally exercise a certain amount of control over their position and work that the hourly employee does not. So it's really crucial to get that judgment correct and make sure that you have applied it correctly. Salaried employees usually have authority to hire and fire other employees. They also have supervision sometimes of work. And sometimes they do direct management of client accounts. So there are things to think about and consider when you think about what a salaried employee is versus what an hourly employee is. Let me give you an example of hourly employees. Hourly employees, people in retail who come in and work for you certain hours a day and you fill out a schedule and they're in the schedule for certain hours. Yeah, those are hourly employees and you can't say they're salaried. um, because they're coming in and they're putting in set hours for you and you have to pay them overtime. Right. Does that make sense to everybody? Questions on that, Simeon?
Yeah, just if you know, but if you are working with payroll, would that be identified in the payroll? That somebody's non-exempt or exempt when you're
Ye-
starting, say, work with
Yes, you
third
would you
party.
would you would have to identify them because that's going to change how they're paid and what you have to communicate to someone who's doing that bookkeeping for you, if they're doing it for you, is how many hours so and so worked this week so that they can get paid, right? One of one of the reasons small businesses lean into salaried and the salaried idea is they don't have to track all that stuff and it minimizes paperwork. And they're just trying to create efficiency and less hassle for themselves. You can't do that. It feels easier, it's nicer, nobody wants to track their hours, it stinks. You got to do it. And that's
Thank you.
just the way it is. All right, Laura, are we ready for the next slide?
I'm ready.
All right.
Okay. Do we need to offer health insurance to employees? That's what this slide is about. If you have over or 4 or more full-time employees, you either have to provide health insurance for them or pay to the Department of Taxes, with the healthcare fund contribution. So under 4 employees, you don't have to provide health insurance per the rules of Vermont. If you have over 20 or more full-time employees, you have to do that, as well as offering COBRA, which is the employee can elect to get health insurance after they're done, after their employment has ended. They can elect to get continued health insurance, and the employer would pay for that. Then also it's a requirement to provide sick leave in Vermont, to provide sick leave for your employees that are working over 18 hours a week. And that looks like, as you can see, like 5 paid sick days. And
Pause a second, Laura. We have a question.
okay.
Are owners counted as employees? And this is, do you feel comfortable answering this? You want me to answer it, Laura?
You can answer it.
All right. So it depends because I'm a law professor. I say that a lot. Laura's going to laugh at that and says Octavius. And in this case, it depends on whether the business is paying you as an employee or you're taking a draw, right? And that's going to be the way it's considered. Um, if you're taking a draw, you're not counted as an employee under this. If you are taking a salary or you're taking an hourly wage, then yes, you would be counted as an employee.
So can I just follow up with you on that?
Mhm.
So if you if you operate an LLC or you are a sole proprietor, you would be taking a draw in that.
Not always.
Not always. Okay. All right.
LLC, so sole proprietors, yes, you're always taking a draw. Um, in a case of an LLC, you can set it up so you are taking a salary. And there are certain tax, this is an accountant question, really. There are certain tax benefits that you can have if you take a salary. I ran an LLC for years and took a salary, and I did that because the actual tax benefit to me as an owner of the business was greater if I took the salary than if I took a draw. I ended up paying overall less to the IRS if I took a salary.
And you're talking about an S corporation there, is that correct?
No,
No? Okay.
no,
Okay.
no, I was filing as a partnership,
Ah,
but I
okay.
still pulled a salary. Um, which is I've had 3 different accountants tell me 3 different things about whether or not that's actually the right gap measure to do that, which is the accounting. What does gap stand for? Something accounting practice.
General accounting practices.
Yeah, general accounting practices. It's the standard for accounting practices. So in some slides, I would have been audited for that, and in other circles, I would have had they would have been fine with it. Right. So that's a little iffy there. But would I have counted towards this count? Yes. Yes. If you're getting a salary and somebody's taking FICA out of the check, right? That sort of chunk of the paycheck that goes to Medicare, Medicaid, and all of those other government services, if someone's taking that out of your pay, that's an employee. If you're taking money directly from the company and you're not taking any of those things out, then that's a draw and you're not counted for purposes of this. Okay. All right, go ahead, Laura.
Okay. Yeah, so Vermont also requires that the paid sick leave, the 5 paid sick days you can have a year, if the employee doesn't use them, they either have to be rolled over to the next year or cashed out. You can't just let them disappear. And that's important to know. And then the Family and Medical Leave Act is for the bigger companies, 50 plus full-time employees. They're required to provide 12 weeks of unpaid leave. And then there are some like areas where you could, Vermont offers income sources, but I don't think that involves the companies necessarily, but yeah, so that's what the FMLA is.
And note for federal, it's 50 plus employees. In Vermont, it's 15 that you have to provide FMLA.
Okay.
Right. So that's a big difference. And Vermont downsizes a lot of these federal numbers because we're small and we have smaller businesses and otherwise it would have no meaning. The other thing I wanted to note in that top piece for the health insurance and COBRA, those are Vermont requirements. And you pay into the Vermont Department of Taxes for the healthcare fund. It is not a federal thing. So lots of these things are about Vermont and sort of funds for Vermonters versus going back into a federal fund, just for those of you who care.
That slide covered a lot. I'd just like to ask folks who are on the class here if they have any questions about this, if something is unclear. Feel free to unmute or put your question into the chat. If we get nothing, then we'll assume you're all good.
Okay. I'm ready for the next slide, I think.
Me too. Now, just to see if PowerPoint is ready for the next slide. There you go.
Okay. And I'm ready to answer questions at the end if you think of things too. Okay, so workers' comp and unemployment insurance is important to know about as an employer as well. Workers' comp is the rates are determined by the state, and the coverage will go through private insurance. How did I lost?
Pardon me, my Zoom
Um,
is doing crazy things, so I'm trying to get it back to normal.
okay. The employee would report. So workers' comp, it covers employees' injuries, um, and that employee would report within 72 hours of their injury. It could be something as simple as just like twisting their ankle or like hurting their finger. Um, it's important that those things are documented because your workers' comp insurance would cover that, or could cover that. So that's why it's so important to pay into it. And the private insurance will set it up for you. Um, and then the unemployment insurance is for if is for when an employee loses their job, they can get compensation. I lost.
So workers' compensation is a private insurance that it's mandatory that you carry. Unemployment insurance comes through the state and you're required to pay in and they get to set the rate. It's quite the scheme. And how you classify a position changes the amount of unemployment insurance you have to pay into the state, as well as things like your frequency of firing and your frequency of hiring impact the unemployment insurance. So being seasonal really jacks up the price of unemployment insurance and things of that nature. So you have to be aware, to have conversations in advance of hiring, in advance of firing, so you know what you're getting yourself into with regards to these rates. Go ahead, Laura. Just having been bitten as an employer over that many times,
Yeah.
I feel the need to share that.
And then for as the agriculture is different, it applies if there's 10 or more employees. And actually, I'm not like confident on the agriculture. 10 or more employees, and then if you're paying over 20,000, then you would need to get the unemployment insurance, I believe. Yeah.
And when you go to register, all of these things are in the forms. When you have piles of forms to fill out with the Department of Labor for unemployment insurance when you file and you register with them. There are check boxes for all of these things. They'll go over them with you. All these things are mandatory and you have to fill out the forms any which way. So you might as well just lean into the Department of Labor who will put you in the pigeonhole they want you in. And you don't really have a lot of options unless you want to litigate, and nobody really wants to litigate with the Department of Labor. Simeon, you have a question.
Yeah, a question for workman's compensation and unemployment insurance. So with workman's comp, if you are finding it challenging to get workman's comp, is it true that the state has a pool if you can't get it through a private insurance?
Yeah, that's my understanding. I
Okay.
don't know what the current status is on that, and I would have to look into it.
Okay. And also for unemployment insurance for no fault termination. So if you fire someone for for a reason, then would they not be entitled to unemployment insurance?
Yeah, that's a great question, isn't it? The state leans hard into paying unemployment regardless. It is really hard to meet their bar. I had several that were given unemployment insurance when it was pretty clear from all the documentation I had that they shouldn't have been. It's not worth the fight. It brings the percentage points up on your unemployment. they use percentages, and I think I went up 0.2 because they gave out unemployment insurance. It's better just to let it go. It's really hard to fight and win on that one. And I dug my heels in on one. The guy was smoking pot before it was legal in my office in front of clients. It was not cool. I fired him on the spot. Um, and the state wanted to fight with me over it and say it wasn't no fault. So, yeah, I find it very difficult to work with the Department of Labor on this issue. John, you came on camera. Did you have a comment on that? You're muted, my friend.
No, thank you. I've been listening though. Your case there just put a smile on my face. That's all.
Okay. All right, go ahead, Laura.
Okay. I think
I
that's
think you're set, right?
yeah, I think that's all for me.
And I think we're going to move to Octavius, who's going to wrap us up today.
Yes, we get to talk about fair labor.
All righty.
Fair labor concerns just about every business for employers. They must pay all their non-exempt employees that we just talked about. They must pay them minimum wage at the very least, and they pay them time and a half after 40 hours. And to do all these things, you must maintain a record and be sure that your non-exempt employee is non-exempt and not exempt and not an independent contractor. The only way that you can do these things is if you maintain record and timesheets and make sure your, your T's are crossed and your I's are dotted on who's who and what's what. And then we have OSHA and VOSHA. OSHA is the standard occupational safety and Health Administration, and VOSHA is Vermont's standard. And Vermont enforces the federal side of OSHA. But generally, they both intend to maintain and secure the safety of all employees while they're on the job. Employees are allowed to report employers or the business to OSHA if, let's just say, the employee reported to their boss and said, hey, the ceiling is leaking, and then the employer didn't do anything. The employee can then report that to OSHA because the employer didn't take protective measures to remedy the issue. And once the employee does file a claim with OSHA, they cannot be retaliated against by their employer. They cannot be fired. They can't be demoted. Their position can't change. Nothing can happen to them because they were just doing something that should have been done by their employer. That's it.
Any questions about VOSHA and FLSA before we leave this slide? This is complicated stuff sometimes, and getting it right is important. All right.
What if I have employees that I don't pay by the hour, but I pay them by the job? How does that work? Or do I have to pay them by the hour?
You can pay them by the job. When you pay by the job, you're leaning towards independent contractor. Your specific situation needs to be evaluated by an attorney to make sure that this is all meeting your specific needs. Okay. I won't get into that here because it gets into some confidential information that you shouldn't be sharing on this particular channel. Okay. Simeon?
Yeah, so I'm curious, I don't know if you're going to touch on this, but if as part of the employee's work, if they have to drive, in terms of, say, using their own vehicle, and counting mileage and reporting that, can you talk at all about that aspect of your responsibilities to an employee?
Depends on whether it is an employer provided vehicle or it's a personal vehicle, right? When it's a personal vehicle, you can make it part of the employment conditions that they carry their own insurance and that they're responsible for their own vehicle. So it has to be outlined carefully is really the response. And it varies, right? It's clearly when it's an employer provided vehicle, the employer's responsibility. It is not clear always when it is an employee vehicle and they're driving on behalf of, I'm thinking pizza delivery people, right? Domino's wouldn't make any money, and it clearly is making plenty of money, if they took on responsibility for every vehicle and every crash that the 4 teenagers that they hired to deliver pizzas were in. Right. So. All right. Next slide. So this one is mine, and this is where we come in and jeez, excuse my Zoom capacity today is clearly lacking. Miscellaneous points and questions that people may have. Working with minors and volunteers. Generally, under 14 is prohibited except farm and ag work and family stuff. As we noted before, asking your kid to pick up mail on their way home from middle school is not going to get you a violation, right? The 14 to 17 restricted time and hours. In some states, they require you to file a form with the Department of Labor that says, hey, I'm working with someone who is under the age of 15. Vermont doesn't. Sole proprietors, 1 or 2 employees, solos and co-owners, most benefits don't apply to you if you're a solo or you're a co-owner. Guess what? You don't get any of those benefits. On the other hand, you get to draw directly from any profits from the company. So it kind of balances out. 1 employee, some benefits may apply, but not most. And by the way, when you just have 1 or 2 employees, this is the time when it's worth using a couple of those free hours that the Small Business Law Center provides to consult with an attorney, just to check in and make sure you're doing everything you need to do and not more than you need to do if you're in a 1 or 2 employee situation, right? Most benefits apply if you have over 4 employees. Childcare businesses are weird. Childcare businesses have all kinds of extra added responsibilities because you're working with people's kids under 5, right? And sometimes over 5, right? You have to have an employee handbook if you're a childcare business. If you have less than 3 employees, even as a childcare business, you probably don't need to have one. And if you have less than 3 employees, I wouldn't even recommend having an employee handbook. They're more trouble than they're worth at that point. As we said before, employee handbooks are considered in most instances a contract. You got to do what you say you're going to do in the employee handbook if you give it to them. So don't put anything in there you're not willing to do. And you can always amend an employee handbook, right? So let's say you create this lovely employee handbook, you have it for your employees, and you realize that one of the things you put in there you just can't manage. Amend your employee handbook. There's no reason not to, right? It's not like it's set in stone. You can always amend it. So keep that in mind. Copyright issues. So work for hire agreements. If your person is an employee, you own what they create. Okay. They're working for you. They're your agent. You own what they create. On the other hand, if they're an independent contractor, they may own it all and you may have nothing. So be careful how that works and how you contract with an independent contractor. Okay. Include in employment agreement or offer letter that it is not a work for hire, or that it is a work for hire, pardon me, and that you own those things. Always, in any case, when we say document, part of that is to cover yourself. Part of it is to clarify the relationship between the 2 parties, right? it's better not to have a disagreement. It's better to go into the situation understanding and having expectations that are the same on both sides. The reason we conflict is when the expectations are not the same on both sides. So the way to clarify that is to say directly, if you're working for me, I have a graphic design marketing firm. If you're working for me, we own what you create, and sometimes the client owns what you create, but you do not own what you create. In many instances, an employer will negotiate with the employee the right to use it for their portfolio or use it for display to say, I did this work, right? And that's perfectly reasonable, but know it in advance and don't leave it until you're firing that employee to work out. It's not a good plan. It's not a good approach, right? You want to make sure you do it in advance. All right. So a little bit about the Small Business Law Center. We offer free legal educational consults. You go and you sign up with us for a free legal educational consultation. It's a 45-minute consultation. We answer your legal questions. We do not provide advice during that. So we were not going to look at your situation and say, here's what you need to do. We are going to say businesses like you do the following things. All right. What we provide for that specific advice need is a referral to an attorney and up to 10 free hours of legal services. So we really encourage you to reach out to us, right? And to talk with us about your legal needs. Simeon.
Yes, thank you, Jeannie. Would you mind just going back to the second to last slide for me?
This one?
And while you're doing that, I'll certainly put a plug in for the Vermont Small Business Law Center services. It's it's fantastic, and I'm so happy that it fills that void. So many people had a hard time accessing legal help for their business before the law school stepped in to do this. So I connect everybody that I work with the Vermont Law Center to benefit from this. So if you haven't, I encourage you to do so. We haven't connected with the law center about this.
Is this the slide that you were looking for?
It's not up on the screen.
Oh, sorry. I have to
Okay.
reshare.
Yes, that's it. So that last point there, 4 or more employees, most benefits apply. Does that and I'm sorry if you said this, I'm not remembering, but does that apply to a total of 4 employees, regardless if they're full-time or part-time versus
Yes.
their status? Okay.
Yeah.
Okay.
Yeah,
Okay.
it does. Now, different laws apply differently to full and part-time employees, but you get kicked over that line when it's full for employees.
Okay.
And
In terms of,
what I mean by different things apply is some benefits, if you're under 20 hours, you do not obtain those benefits, right?
gotcha.
And some it's 32 hours. It just depends on the particular regulation, and it will be on a specific regulation by regulation as to what benefits apply and when.
Okay. And can you speak to having employees sign a non-compete clause and or sign something that says they won't take your clients that they've been serving on your
So
back?
yeah, and I'm gonna stop sharing for that because we don't have a slide that addresses that.
Sure.
So let's do NDAs first. NDAs, yes. An agreement not to disclose information or trade secrets or things of that nature that are part of your business. Those are upheld, and those are pretty strongly upheld by the courts. Non-competes are tricky, particularly in a situation where it is your profession. For example, I'm a lawyer. If I go to a law firm, they can't have me sign a non-compete because that's my profession. I'm going to go out and do legal practice somewhere else if I leave them, right? So those kinds of non-competes are not upheld by the court. But what the court won't uphold is a non-compete that stops you from earning a living. That's generally the kinds of non-competes that a court won't uphold. However, if you're a business and you're selling out to another business and you agree not to compete directly with them or take their clients, yeah, they'll uphold that. But what they won't do is stop you from earning a living. That's where the line falls. And I'm summarizing that. It's more nuanced than that, but on the whole, that's where it falls.
Thank you.
Other questions? My students have anything to add? What did I miss? What did I overlook or gloss over?
I think you did well, Jeanne.
And you guys did a great job. So thank you. Thank you both for preparing for this and putting all the work into it. I have Steinmetz here. I'm not sure what your first name is. My apologies.
That's okay. I'm Brian Steinmetz.
Hi, Brian.
Hi. I'm a real estate broker, and I'm thinking about hiring some agents to work for me soon. I was curious if it would be better to have them have them set up their own LLC when I hire them using a 1099,
Depends
or
on there are so many it depends there, Brian. The first thing I do is talk to your accountant, right? And see what those financial implications are for you. And then after you talk to an accountant, talk to an attorney. Some trades, it is not unusual that independent contractors, they're just considered independent contractors. I believe real estate is one of them. Unless you're specifically giving them a desk to sit at, then as soon as you start providing supplies and goods and things like that, that's when you sort of fall into the employer piece. So in your specific situation, it's worth an hour of an attorney's time, frankly, not to make a mistake on that one.
okay, thank you.
You're welcome. Other questions? All right. I didn't think we'd eat up 2 hours, but we've done a pretty good job.
Well, thank you so much, Jeanne. Really appreciate it. And thank you, Octavius and Laura. Thank you for all of your help and information and time. We really do appreciate it. And I don't mean to put you on the spot here, Sophia, but I'd like to put a plug in for our upcoming social media classes. Are you able to just relay that information quickly to folks, or at least perhaps put it in the email that you'll send out to people?
Yeah, absolutely. I can do both. So next Thursday, February 27th from 10 a.m. to noon, we're having our first of 3 social media classes, and it's just an intro to social media for small businesses. We're going to continue that series on March 12th from 10 to noon on email marketing for small businesses. And finally, the following week, March 19th from 10 to noon, we'll have LinkedIn for self-employed professionals. So all 3 classes will be geared towards small business owners or those looking to start a small business. I will include the link to register on the email, but since you've all registered for this class, you can also email me directly. And I can just send you the link to the Zoom.
Great, thank you so much, Sophia. I appreciate it. And just so it's clear, there's no fee. The class is free to participate. And again, it's virtual, so makes it a little easier to attend. So I'd like to
So my law students that are thinking about becoming LinkedIn professionals in the future.
Yeah, let them join.
If
Yes,
you're
they're welcome.
if you're interested, that is the skill that I see law students without that they really need to get is social media. So I'll plug this for CVOEO. Get yourself a LinkedIn site and be out there marketing yourself and creating your brand, because it'll do nothing but help you get a job once you're done with this law school thing.
Great. Well, thank you everyone for joining us today, and just expect to receive that email from Sophia. Again, thanks for joining us today, and please take advantage of the Vermont Law School's 10 hours and connect with them to move forward with that. So thank you, everyone.